So what questions do you have? Michael's a lawyer and I'm a lawyer.
I kind of asked my legal question already.
Okay.
Oh, okay.
Ask Michael.
Copyright.
Okay.
Intellectual property. So I'm making a documentary, and I'm having to get a lot of images and music and footage, etc. And I'm going to websites that can give it to you free. But not everything is there that I need. So therefore, I'm going to Google Images, and I'm going to try and find the owners of the images and the sound and the music that I do find there. I email them, they don't answer. So I assume I cannot use it. I don't get permission. I didn't get permission from them.
So with documentaries, one of the places that I recommend documentary filmmakers go, and I can't remember the exact site, but it's put out by American University, and there's best practices for fair use in for documentary filmmakers. And they actually have an infographic there that I found pretty astounding, that since they implemented these fair use best practices, that 90%, so something like 90% of documentary filmmakers who have stated that they followed the best practices have had no issues with lawsuits or with cease and desist letters. So I recommend following that as a guideline for documentary filmmakers, because the issues of fair use for many documentary projects differ from narrative. In terms of, now, as Mark and I talked about last year, fair use is a case-by-case basis. And there's no license for fair use. You don't just go out there and say, I want to sign up for fair use. Most people would consider fair use an affirmative defense to copyright infringement. Some people consider it inherent right. And there are a lot of indications, including a recent Supreme Court case, that indicate that there's more favorability towards the concept of fair use, but I would never advise somebody and say, this is slam dunk fair use, have at it. So that would be my first piece of advice.
Well, I went to Volunteer Lawyers for the Arts, and I asked a similar question, because this is my issue right now, and they said basically the same thing you said, but what happens is that they have to take you to court, so you have to have the money to go to court to defend yourself, so that's...
Yes, there's legalities and practicalities, and that's one of the real issues here. Is how do you protect yourself? Do you bankrupt yourself from trying to license copyrighted content, and that's why I was actually really surprised by these statistics that were put out by American University. This 90% success rate.
But you don't know that it had anything to do with what they said. It may have been 90%.
That's right.
Anyway.
And so so the reality is that first, I would always recommend, now I'm an attorney, I would recommend you bring the case-by-case basis to an attorney to review, because I don't think that there's one true answer depending on what you're talking about.
To that point, to what you're saying about being sued, that's why the Happy Birthday litigation happened, right? Because it was people for decades thought it was cheaper simply to pay the license fee than to worry about having to pay a lawyer to determine whether or not Happy Birthday was in the public domain. This one film producer said, I care. And so she got a law firm to represent them, and they got Happy Birthday declared as a public domain song.
And it's that was a $1,500 license, and Warner Chappell is now, just because they decided to push on it. I think the documentary filmmaker was relying on that.
Of course, but the notion, your point is well taken, that there's legalities and practicalities, as Michael was saying, and so you're always better off getting a license at a relatively minor fee as opposed to doing it, unless you happen to know that you can absolutely get away with it, and there's case law to support it. But even the most recent case that deals with images which is Carry You, in the Second Circuit, if you, where the guy took images from a pre-existing work and incorporated them into his work, and you look at the ones where the Second Circuit said, this is fair use and this is not fair use, you and I and Michael cannot declare why this one is not fair use and this one is. You cannot do it. So it's entirely in the eyes of the beholder, which makes fair use very difficult. So your question is, if you can't get the rights, you can't use it.
Now, to get back to this Carry You issue, in that case, you're dealing with an artist who likes to push the envelope and has the deep pockets to do so. And so, he last year pushed the envelope even further. He took these Instagram photos and he blew them up onto canvases, gave his own commentary, and you know what? He has a legal basis. A legal basis for his fair use argument because there's a case involving Google called the Perfect 10 case, which dealt with thumbnails. Well, here he blew up these pictures. Do I think it's a great case? No, but he can afford to be sued, and he was selling these images on canvases for up to $2 million. I think. I mean, it's insane. So this gets back to the legalities and practicalities, and your stomach for risk, your attorney's stomach for risk, and what the workarounds you can do.
Thank you.
I do background acting, and they're very big on signing no release. You can't say anything about the film or the movie before it comes out. I'm curious, after it comes out, and say like I'm in a little clip, I want to take like a screenshot of it and put it up on social media and say this is something I was in. After the movie came out, is that allowed, or is that also part of the non-disclosure?
Depends on what it says.
Yeah. What exactly does your contract say?
I've just done a couple of different ones. I haven't even looked at it, so I just started. So I was just kind of curious because they were talking about someone released something about Spider-Man, but this was before it came out, and they sued this background actor for like millions. But again, that was before it came out. The specifics of the contract, I don't know. I'm just kind of
depends on what it says.
You're thinking of it. All right, thanks.
But it is copyrighted. That's the one thing that's clear.
Yeah.
So you have to take that into consideration.
Mm-hmm.
There is the possibility you could be infringing, but again, we're also talking about whatever they allowed you to do in your agreement. It's something you should consider.
The other thing we should say is that when you ask us questions, we're not your lawyers.
Yes.
Okay? We're just asking you questions in an informational thing. And the reason I say that is because we haven't established what's called an attorney-client relationship. And when we do establish attorney-client relationship and we screw up, then you can sue us. But if we screw up today, you can't. That's basically what I'm getting at, okay? So this is really informational. There's no attorney-client relationships. And he says, yeah, I agree.
Yes, I absolutely agree. And one of the reasons is because, just as you put it, we don't have the contract in front of us. We don't know your history. We don't know all the other factors. And, and when we haven't seen the images. We haven't heard the songs. We haven't seen. These things are subject to clearance, to searches, reviews of contracts. There's a whole constellation of things that an attorney needs to.
So now that we've covered our asses, you can ask us whatever you want.
I mean, the thing is this, right? I mean, of course, they're attorneys. I'm not an attorney, but the confidentiality agreement is to protect the value of the movie prior to release. They don't want secrets to be out that's going to stop people from potentially seeing it, because now that you ruin the ending of it or something like that. I mean, I logically would doubt that they're not gonna come after you after the movie's already out, because there's nothing that you could do that's gonna hurt the value of the project to say you're gonna hurt our profit margin because you gave away the ending. You're just putting a picture up of your likeness. They're not going to bother you.
Remember, he's not a lawyer.
Right.
I mean, it's not like you're going to make a huge profit off putting off the picture. Like I said, for recording artists, right? If for a lot of this is big in the rap industry, right? People will take already released copyrighted material and they'll sing and perform over it and release it, but they're not releasing it for any profit. It's a promotional use only situation, and nobody comes after them.
That's because they're lucky.
Right, I don't,
That does not mean that they're not committing copyright infringement,
Right.
and that is a horrible example.
Promotional use only, nobody.
Correct.
yes.
Statutory damages entitles the copyright holder to damages of up to $150,000 per infringement and an injunction. So if you want to put it out on a promotional basis and run that risk, as they say in Yiddish, sei gesinnt, go with God. But that doesn't mean you're not going to get sued, and I've seen people get sued, and I've written those demand letters. So knock it off.
And to bring up the whole confidentiality thing, I don't know if you heard about this, but the Walking Dead people have been very, AMC has been very active in going after people who are revealing upcoming scenes and upcoming episodes of Walking Dead.
See, but he's talking about after it's out.
I understand, but I'm just saying that I think people in general, lay people in general, have a skewed sense of what fair use is, of what copyright is, of when copyright begins, how people can protect copyright. For instance, I mean, you've got the author of the Digital Millennium Copyright Act here, so he can tell you everything about takedowns, takedown demands. The reality is that there's a safe harbor for the Digital Millennium Copyright Act for companies like Google, but if you're infringing and you're not one of these internet services, right away you can be sued for statutory damages for infringing copyright. And there are these companies, I know attorneys who have gotten these demand letters for what was perceived as copyright infringement, and they're scary looking letters. And now there's so much software that can identify, and I don't mean to make this fear mongering, but identify images. There's content key for music. There are all these ways for very sophisticated companies to be, some people would say, copyright or trademark trolls, but I think that there's a legitimacy to that, and so you cannot assume fair use.
Yes,
I have a question. I'm sorry I was late, so I don't know if you covered it. For script ideas, is there such a thing as legal, like, poor man's copyright anymore? You know, no, there isn't, right?
Copyright begins before you register with the Copyright Office, but you are not entitled to certain privileges. It begins with the fixing an original idea in a tangible medium. That's when copyright begins, but registration, it's so cheap. And you can do it now through ECO. I think it's $55.
Here's how I like to say it, okay? Copyright subsists at the moment of creation when you fix it in a tangible medium of expression. So when you type it up, you have a copyright in it right then and there at that moment. There's nothing to do. If you want to sue somebody, the key to the courthouse is the registration certificate. And in my opinion, if you register at the Writers Guild, you're throwing out your money. People will register at the Writers Guild, and I have this debate going on right now on a website where it costs you $35 to register a copyright. It proves clearly that it existed on that day, and you get the keys to the courthouse in the event somebody else infringes on your copyright. If you register with the Writers Guild, it establishes that certain people were involved in your production, and it establishes that it existed on a particular day. It costs you $20, and in 5 years they throw out the records. And then you have to register again for another $20 in 5 years, and then another $20 in 5 years. To me, it's a waste. So I encourage people to not bother with the Writers Guild, because $35 and $20 in the grand scheme of a motion picture is not a lot, but it starts to cost money. So I would say register at the Copyright Office, and then if you do a complete rewrite 2 years later and it's a wildly different script, then register that one. But once you register it, you're done. And ECO is what he's talking about, is the Electronic Copyright Office. You take your PDF or your Word document, you upload it, you put it on your credit card, and you're done. It's really very simple, and you're protected. Yes?
With regard to fair use, etc., I recently worked with a director who refused to let me Greek out or change or obscure any copyright. Refused to let me.
What do you mean?
She said it was fair use.
Okay.
I know for a fact it isn't. I was production designer on it. How do I ever go on? I mean,
could
I
be.
can get a black eye in the industry.
Well, you could be, and it's actually a really interesting point, because I'm going through this on another property now. So, there's something called vicarious and contributory liability in copyright infringement. Copyright infringement does not require intent to infringe. So, if Michael writes a book, and I publish it, and you sell it in your bookstore, and he took some portion of that content from George, we're all liable for copyright infringement. Even though I never even read the book and you never read the book. Strict liability. The fact that your material is sold by her in the store that he wrote and I published makes us all liable for copyright infringement. No intent. But we're all liable anyway. That happens in your case, right? Because you knew that this was infringement.
Yeah,
You told her.
yeah.
And unless you are named as an additional named insured on the insurance policy, if there is a suit, you could be liable. That's the fact. That's the point with regard to copyright infringement. It's strict liability. I represent a company called Varsity Brands. They're the largest cheerleading organization in the world. Okay? For 35 years, they let people put music together into cheers. Took 30 seconds here, 30 seconds there, boom. Sony wrote us a letter and we went, oops. So I've been spending the last year fixing the cheer industry. That's about 100,000 kids a year who participate in cheer and dance. And no more popular music is used in cheer that's sponsored by my client. It's insanely difficult. Why? Because my client has the ability to control the music. We could have said for the last 35 years, no popular music, but we didn't. So we faced liability. So we made a deal with Sony, and now we fixed it, and everybody's happy, and it's going forward. It's great for me, because the client pays me a fortune to fix this stuff. But that's what you're faced with. That's the nature of copyright infringement. Yes, you have liability.
Also, just, and to follow up on that, because I used to be a plaintiff's attorney.
You used to be?
I used to be a plaintiff's attorney.
Okay.
I used to sue people.
Yeah, gotcha.
And when you sue people, you generally, you cast as wide a net as possible.
Sue everybody.
So
Yeah.
there's a very strong chance that there's somebody going through, well, who are all the possible people who contributed to this infringement. So it is a real possibility, and you cannot let somebody just make you complicit.
I have a question. Did that cost the, whatever group, cheerleading a lot of money?
Who?
The cheerleading group that got...
Oh, yeah. Oh, yeah. Lots of money.
Even though this is what, I don't know, what is it, high school, is it professional?
Yeah, even though it was promotional.
Oh,
Terrible.
so you're talking about like high school, you're not talking about professional cheerleaders here?
No.
So the resolution to that, though, is that during cheerleading competitions, they can only use,
Original, right.
they can't use any popular music for any length of time.
Can I, just curious,
It's a big
are
change.
you able to disclose how much it cost the group? No. Because I mean, in a way, they're promoting Sony's music.
Yeah.
Yeah.
Sony doesn't give a
They
shit.
don't care.
That was a change in fitness recently, where you can't play certain music in fitness classes anymore because the artists aren't getting the royalty by the,
How about that?
yeah.
That's all my fault.
I used to work for ASCAP, and my job was to send those letters to yoga classes and
I mean, because
exercise
it's
classes.
previously been up to
I got one of
promotional
those letters.
stuff.
Promotional use is irrelevant, okay? So, you're a songwriter, aren't you? You
Yes.
write a song, right?
Yes.
Okay, and I'm making a movie, and he's gonna appear in that movie, okay? I'm making a movie, and I'm gonna use your song in the movie. I'm gonna put it in there for 2 minutes, and it's gonna be in the movie. It's promotional. How do you feel about that?
Of course I don't like it.
Okay, end of discussion. End of discussion. That's it. That's all there is to it. You own it. It meant you spent $50,000 making that record. You brought your friends in. You redid the verse. You did this. You did that. You did 1,000 things to make it perfect, and I'm using it for promotional
I
purposes.
can't argue with you as the author of the digital copyright, but what I'm saying is for a fitness class, I might be able to understand because the participants pay for the class and therefore the instructor is making money. But if it's somebody, I understand the issue, but if it's a person who is, say, rhyming over copywritten material, but they're not selling it, they still are
Let me
marketing
just
their
stop you right
brand.
there. Let me just stop you right there. Bullshit.
Yeah,
They're selling.
yeah.
Why would they do it otherwise? They're not making money off it? Baloney. They wouldn't do it if they weren't making somewhat money off it somewhere.
They're
Guaranteed.
making money off it somewhere.
So there you go.
No.
End of discussion. We gotta move on.
I have a
However,
question
they
for
can
you.
get licenses, correct?
Yes.
Yeah, they can get licenses, but what he's talking about is not paying a license and doing it for promotional purposes.
I have a question for you. Do you think that, because there are changes being made to DMCA and possibly other elements of the Copyright Act, do you think that there's going to be an increase in allowability for fair use in certain situations?
There's a 162-page report by the Department of Commerce discussing remixes. Okay? The Department of Commerce has no jurisdiction over copyright. Okay? Remixes, mashups, and medleys are a gigantic problem in the copyright industry. And the Register of Copyrights has weighed in on it. The Department of Commerce, which has nothing to do with it. The Digital Millennium Copyright Act that we wrote in 1995 did a really good job for about an hour, but then it stopped doing that good job because what happened was you have Google that now gets 1 million takedown notices a day. So it's not working, and it's not supposed to be whack-a-mole. So will there be changes? Will it be easier? Probably. Will it cost more money? Probably. I don't know how it's going to shake out, but there will be changes. Yes, sir.
As a musician and a photographer, I have to say that it's a vested in when you do it for a living, when you put food on your table by creating images and creating music. It really is personal. It really does affect you in certain ways, economically or just emotionally, that somebody's using your material without using it. Is it still the case that if a DJ plays a copyrighted piece of music at a wedding? I know there was cases years ago in California where they were actually shutting down weddings saying you're infringing copyrights.
See, you're getting into a music area, so it's a little different, and you could talk to this. Why don't you answer this? Then?
About music?
About ASCAP and weddings.
Oh, no.
That's really what he's asking for.
I mean, ultimately,
I'm not
somebody's
familiar
making
with
a
the
profit
with the
off
wedding
the
one,
work,
but
your intellectual property, right?
generally places get a blanket license, and
Should get.
right. So and the aerobics classes, or more likely the restaurants, but and there's a specific size, a restaurant or facility where that would trigger the. And I worked in general counsel's office at ASCAP, but there are field operatives.
So the answer is, if we were to play music here, right, for example, this place should have an ASCAP license and a BMI license, so we could perform the music if there was going to be a wedding, and that would be okay. But if I were to take a bit of your song and save it to a CD or digitally, and then take a bit of his song and save it to, and then I took his song and I put it together, and I created this song that's copied with 3 elements, I would be committing copyright infringement. And that's the problem with the cheerleaders, okay? But if I took each one of those songs and I played it, and I played it, and I played it, and I had an ASCAP and a BMI license, I'd be okay.
Now, let me ask you, because last year, it was this year, right? Lens, the dancing baby case.
Yeah.
Does that affect anything? I know that because there was a case where they found that against Universal, and they found that before sending out takedown notices, that there has to be an inquiry into whether the, fair use was considered. So basically, that eliminates a little bit the robo takedown notice, because there has to be the inquiry into whether there was fair use. Does that practically change for the little guy?
I represent hotnewhiphop.com. You may know this website. It's a news site for hip hop artists, they get hit with robo stuff every day.
Really?
On a regular basis, and they don't post anything on their site. They just link to SoundCloud. So the robo copyright trolls are sending out notices telling them to take stuff down off their website when it's not on their website. It's on SoundCloud. And SoundCloud has a license, and the SoundCloud agreement says if you put it up here, other people can link to it on their sites. So it's automatic. It hasn't changed a damn thing. I don't know what it means to consider fair use before you send a notice and takedown, and I don't think anybody else does either. So I don't think it's going to make a difference. So what else can we talk about? Film.
Oh, contracts.
Let's talk about film.
Contracts.
Yes, ma'am.
All right, a couple things about contracts. You said that if you're doing a documentary based on this man's book, he's given me permission to do it. He's really being very cooperative, everything. Do I need to put that in a contract form, number one? And the voiceover actors, the narrators, anybody else that is part of the film, do we need to actually work on contract? The music that I'm licensing and everything, does it really have to be put on in contract?
Let me be direct. Yes.
Yes, that's what I'm afraid of.
Yes.
Are there
disagree?
boilerplate?
No, not only do I not disagree, this is something that blows my mind because it's only creative people who ever ask this question.
They're all my friends.
I understand.
Got it.
But it doesn't matter. In my opinion, contracts are the ultimate form of respect. It says, I care enough to establish our mutual understanding of the agreement we're about to come to.
Are there boilerplate contracts so we don't have to go to, I'm sorry, so we don't have to go to an attorney?
They're worth what you pay for them.
Right.
Okay, thank
But
you.
the answer is yes. The answer to both your questions is yes. You must have a contract for everything that's in your movie. And particularly with regard to music, I'm going to go back to music even though I said it shouldn't. Every piece of music has to have 2 licenses, not 1, 2.
The mechanical?
Nope.
No?
You need a license for the recording, and you need a license for the underlying song. And if you don't get both, you're going to get sued because it's not promotional.
From my friend, I'm gonna get sued?
Yep.
And if I was,
Because he's going to die, or he's going to sell his rights, and the person who bought them is going to sue you.
and if I was doing a documentary on a musical entity, same applies.
Absolutely. You need the publishing and you need the recording. And sometimes I've cleared songs with 22 publishers. Hips Don't Lie has 10 publishers. I cleared that song. I'm telling you, and each one gets to make their own deal. So if I own 10% of a song and he owns 30% of a song, and he says, I want $10,000 for my 30%, that doesn't mean I get 1/3 of that. I could get $10,000 too, just because I feel like it.
And there's something else. You said you're making a documentary about a musician. Well, state by state, there are different rights of publicity, which become very problematic. In fact, Prince just died, and it's tabled now. But there's a Prince Act, which may become the most, from certain people's perspective, the most egregious form of a right of publicity, where heirs can just basically demand money for the use of the person's name and likeness for commercial use. So it's not just copyright that you have to contend with, and it's not just the copyright of the music. You need to consider that there are a number of different facets, different ways that people can sue.
But also, the heirs can lose everything because he did not have a will. And if they find out that he had a child, that child in Minnesota will get all the rights to everything.
Well, that's what's going on right now.
But
Nobody knows
what do you mean
who
the heirs can lose everything if they don't have a will? The heirs are the people who inherit the
Right, but
estate.
in Minnesota, isn't it true that supposedly there are some paternal suits?
There are 30 people that have claimed to be heirs, okay? So the heirs will be determined, and they
Okay,
will,
that's a better way of putting it.
and
That's
they will in
concise way of
turn
putting it.
determine what rights get sold. But there will be a lawsuit over who actually inherits that estate, and those are the heirs.
Now, New York doesn't have a right of publicity for dead people. And actually, a right of publicity is part of the right of privacy in New York. But you have to think about what's going to happen with your project in other states. And so,
And then if this person is multi-state, each state.
well, there's forum shopping.
Well, every state's law is different. If you're going to release a picture across the country, Tennessee protects its dead celebrities. This guy named Elvis Presley lived there, so they protect them, okay? New York does not. California does. So no one would sue for a right of publicity case in New York, but they sure as hell would sue in Tennessee or in California. So if you don't have the right protected, you got a problem. Or the rights granted, I beg your pardon.
Can
Yes.
you go on a little bit more about what's legally unique to New York as far as films? Like, is it easier to make films here? Is it harder? Is it legally more complicated, or are they more generous? Or
I mean, making films, like getting behind the camera and shooting, it's the same. But New York has a tax credit, Connecticut has a tax credit, Georgia has a tax credit. The New York tax credit, in rough terms, is 30% of certain below-the-line expenses. And they will tell you what that's worth before you start shooting. So then you can take that, if you set up the right structure, you can take that to a bank and borrow against it, assuming that you have a completion bond. So that's possible in New York. On the other hand, in Georgia, there's a 30% credit, which is above and below the line, but they won't tell you what it's worth in advance. You have to wait for the picture to be finished, you file your thing, and then they send you a check. And then there are tax credits, and then there are tax rebates. New York is a rebate state where they write you a check. Georgia is a rebate state where they write you a check. Puerto Rico is a credit jurisdiction where they say, oh, we'll give you a 40% tax credit. Well, you're a filmmaker coming to Puerto Rico to make a film. What are you going to do with a tax credit worth, I don't know, $2 million? You don't pay taxes in Puerto Rico. That's a credit off your income tax. So if you had a $2 million tax bill, you'd use the credit and you'd turn it into zero. So what do you do with that tax credit? You sell it to somebody who does need that. So you sell the $2 million credit to Coca-Cola. But they don't buy it for $2 million because that's worthless. Why would they pay you $2 million? They could just pay the government the $2 million. So they'll pay you $1.8 million. So your $2 million tax credit is now worth $1.8. That's the differences in jurisdictions. When we did Conviction many years ago, there was a 42% tax credit in Michigan. We used it there. Like I said, it's 40% in Puerto Rico, it's 30% below the line, plus another 10 if you shoot outside New York. And New York also has I believe it's a 35% post-production tax credit. So if you shoot in, I don't know, Indiana, or you shoot in Iowa where there is no tax credit, and you come back to New York, 35% of your post-production expenses in New York can count towards your tax credit. Again, they'll pre-certify, you can borrow against that, and there are things in the post-production tax credit that don't appear in the production tax credit, even though it's part of the production. So if you hire a music composer in New York and you're looking for the post-production credit only, that expense counts towards the post-production tax credit in New York. But if you hire that New York composer on a production tax credit, it does not count, as an example. So, I mean, there are lots and lots of nuances that you really have to go through. So the differences depends on the state, depends on what you're looking for. And the reason this is here is because we typically sometimes talk about how you structure borrowing against the New York state tax credit. And unless two people ask me, I won't do it.
How do you structure borrowing against the New York State tax?
Does anybody else? Okay, so this is complicated.
This is great, though. He did it last year. It's terrific.
You have a marker? I don't record it.
By the way, yesterday the New York State tax people were here, and I didn't attend, but last year I did. And they are very eager to hear from filmmakers. They seem very open to having you get in touch with them.
They are. They're really very helpful. Okay, so we're going to learn a little bit of, this is the legal panel, so I'm going to do this because I didn't do it before on financing and distribution. So when you set up your, when you arrange your financing for a picture, you're going to set up what's called an LLC, a limited liability company, right? So that's not a corporation, and it's not a limited partnership, and it's not an individual. The characteristics of a limited liability company are that it pays no income tax. Fundamentally important. You elect it to be treated as a partnership, it pays no income tax. We all pay income tax, okay? We could set up an entity called an LLC into which people put money, and then all the money that goes into that gets spent. There's no income, and then when the money comes back for selling the picture, let's say it cost $1 million to make the movie, and we get $2 million back. The investors get back their $1 million. They get back 20% more, so now they got 1.2. Now there's $800,000 left. The investors get $400,000, and the producers get $400,000. Remember, so all the income came in and it all went down, right? So it has no net profit, so there's no tax to pay. But let's assume for a second that the $800,000 came in and you didn't pay it out that year. What would happen then? In theory, the LLC would have $800,000 in profit. So it should pay income tax, which means that it would lose half its value, because the tax rate at that level is about 50%. So you would lose $400,000. But because it's an LLC, it pays no income tax. So that's a really good thing. Does anybody not understand that?
Well, if I'm a subchapter S corp, is that similar to the LLC?
Identical.
Okay, so I'm cool. Okay, good, thank you.
So now, since it pays no income tax, it also allows for losses to be passed on to the investors. So you put up $1 million, you spend $1 million, and you have no income, you have a loss. So the investors want that loss, because in theory, they can deduct it against their other income. Or, if the picture cost $1 million and it only makes $500,000, you distribute the $500,000, and the investors lose $500,000, they get to deduct that loss off their income, assuming they can. So the losses pass through the entity, the profits pass through the entity, it has no income tax to pay. You with me? Does anybody not understand any part of what I just said? Because it really gets complicated now. Yes?
Yes. You didn't pay it out at the end of the year because of some reason, and you had that 800 in there. Would it then have income tax on that, or it just doesn't automatically? That was the part that wasn't clear for me.
The entity
Yeah.
pays no tax.
Even if it has leftovers.
Correct.
Okay.
But the individuals who are entitled to receive that money are deemed to have received that money. So they will pay tax on that money even though they didn't get it. So it becomes very important to you as the filmmaker to make sure your money that comes in goes out. Because you're going to end up sending these people a K-1, a tax form that says, you received income, but you didn't get any money, so now you got to pay tax on it. They'll be furious at you. Okay, so that's the premise of all this stuff. So now we have an LLC, which I like to draw this way as very porous. Okay? Because the money goes in and the taxes, everything flows through it, okay? So now we have an LLC, and it's going to generate, say, a $200,000 tax credit from New York State. And New York State wants to pay $200,000 to this LLC in a tax credit, okay? But we know we can't get it until the picture's finished, right? So we're going to go borrow against this $200,000. So the bank says, oh, you want $200,000? Forget the discount, forget the interest rate. I'll give you the $200,000, no problem. But New York is very clever. It's the only state that does this. If one of the investors in this thing, because he put up part of the $1 million, happens to owe New York State, say, $500,000 in taxes, New York State takes the view, like that? Okay. New York State takes the view that they're going to set off the $200,000 that they're going to give him against this guy who owes you the money. Michael and I formed an LLC. I'll do it because I'm going to do it in practical terms. I owe the state of New York $500,000 in taxes. I invested $500,000 in this movie, and Michael invested $500,000 in the movie. We're going to go to the bank and borrow $200,000. The bank says, here's your $200,000. The state of New York says, oh, but Jacobson, you owe us $500,000. So the $200,000 that the state of New York is going to give us, it says, no, you can't get it. We're going to set off Jacobson's liability. You don't get any money. Nothing. Nothing. So the bank put up $200,000 against something they can't get their hands on. Does anybody not understand this? It's a set-off. Even though I put up $500,000 in this movie and I owe $500,000 to the state of New York, and the state of New York has promised to give this movie $200,000, I can't get it because the state says, you owe me money, I'm taking the money. Do you understand? It's really very important. So now what happens is, yes.
So the state takes the money straight from the bank. The bank gives you the loan.
The bank won't lend.
Okay.
The bank won't lend unless you do what I'm about to show you.
Yeah.
Okay, so if if you have a liability to the state of New York, the state of New York won't give a tax credit to any person in this LLC if they owe the state of New York money. Yes.
By the way, that does include New York State student loans as a debt to the state.
Okay.
Just so you know.
So you have to make sure that all your investors pay their taxes or are up to date with all their taxes?
That would be the simple way to do it, but I'm a lawyer, so it's complicated. And I can make sure it happens. I don't have to ask that question this way.
Okay.
I did have a partner once who made a deal like that, and made everybody promise they didn't owe any money, and he never did another loan to that bank. So what you do is this corporation, the LLC, sets up what's called a C Corp. So Patricia, what's the difference between a C Corp and an S Corp?
S Corp is, I think, is it smaller? Oh, let's see. My S Corp protects me as a person. If anybody wants to sue, they can only sue the corp. I don't know about C Corp.
Okay, so a corporation protects you from personal liability, okay? Whether it's a C Corp or an S Corp. An S Corp elects partnership status, which means it also pays no income tax, just like the LLC. But a C Corporation pays tax. That's what happens in the C Corp. No pass-through. Remember all the pass-through here? The losses, everything passes through? Nothing passes through the C Corp. It stays there. So this company enters into a contract where it agrees to pay all the money that was invested, the $1 million that came in here, gets paid out this way to the C Corp. And the C Corp promises to deliver a film to the LLC. It's a wholly owned subsidiary of the LLC. Now, the bank will lend to the C Corp, and they don't care who's in the LLC. Because the C Corp is not a pass-through. The C Corp will produce the film, and the C Corp is what applies to the state of New York for the tax credit. Yes?
Does that make your original LLC a financing vehicle and not the actual film company?
I don't know what's a financing vehicle. The production entity, this is a production services agreement where the LLC hires its wholly owned subsidiary to produce the film in New York so that it gets the tax credit and it can borrow from the bank. The banks won't lend to an LLC against the New York State tax credit. They'll only lend to a C Corp. That way you don't have to ask your investors a single question.
But you have the additional tax liability.
So what is that tax liability? Think about it for a second. $1 million went in, the budget of the film is $1 million. So they spent $1 million on the crew, on the cast, on the locations. So what's the profit in this company? Zero. No tax. And so the copyright gets conveyed back, and when you finish, you dissolve the company. And then you file a return, of course, showing all that stuff, but it has no tax liability. It's all done nice and neat, and you were able to get this loan, basically, for $200,000. Yes?
The government doesn't care who owns it, if you all...
Owns what?
Owns either, has shares or whatever in either one of those corporations, or...
Government cares a lot if the New York State tax credit is gonna be given to the LLC,
Right.
right? The government cares a lot if it's given to the C Corp. But since the C Corp has an LLC as the owner and none of the losses pass through it, you can make the loan against the C Corp. As I said, the banks won't lend to the LLC, they'll only lend to the C Corp.
I mean, they don't come in and say, you're all the same shareholders. They don't care.
No.
They don't
But-
know.
But if there is a liability that lives in the LLC to the state of New York from any investor, regardless of the size, it's set off against the New York state tax credit. And this only happens in New York. It doesn't happen in California and Puerto Rico and Georgia or anywhere else. It's the only state that pays attention to this. Yes.
Is it possible that a film could come in under budget, and so maybe the $200,000 would have been, or maybe they didn't meet all the check boxes to get the 200,000,
Yes.
and then what happens?
Well, have you borrowed against it?
Yeah, let's say they borrowed against it, and then it turned out that it was spent, but not in a way that would qualify for the grant, for the $200,000, or.
I don't know. That's a very complicated
Yeah.
question. It's almost never happens where the tax credit is not earned out. Every picture I've been involved in, we've gotten more than what we budgeted.
No.
Yes, sir. No, I'm good. Okay? Thank you, Corey. So, it's important for you to understand it. If you're going to borrow against the New York State tax credit, and the only time you're going to borrow against the New York State tax credit, which if you were here for the earlier session, you'll know, is if your budget is really $2 million or up. Because the only way you're going to get that loan is if you also have a completion bond. So if your budgets are under $1 million, you're going to have to get something from your investors to confirm that they don't owe the state of New York any money. Otherwise, you'll lose your tax credit. What else you want to talk about? So we talked about music, we talked about fair use, we talked about, what else should we talk about that's
More
common?
film.
What?
More film.
Yeah. So, yeah.
So
What's
my question is, me and him are producing our second feature, and he has his own LLC company. Basically, I shared with him a story that happened to me, and I'm wondering if we would be sued for using characters based on actual events. He broke it down into a screenplay that, so yeah.
Yeah, well, actually, I just gave a whole CLE on this, and so this is, there are so many different ways to get sued. It's amazing. And what's really interesting to me about the concept of life story rights is that nobody has an inherent copyright in their own life story. But that being said, there are so many other ways that people can find a way to sue you, and legitimately, so that means that the lawsuit doesn't go away, it doesn't get dismissed immediately. One of the more interesting things that's happened very recently is this case involving a film called The Good Lie with Reese Witherspoon about Sudanese refugees. 54 Sudanese refugees were interviewed and contributed heavily to their stories to what ultimately became this film. They've sued under copyright for joint authorship. Now, this has been tried. There's also a Jersey Boys case involving Frankie Valli and I can't remember his first name, Vito Corbello, I think? No, DeVito, Tommy DeVito, who are members of the Four Seasons. And they're being sued by a ghostwriter's widow, the ghostwriter of DeVito's unpublished autobiography, again claiming joint authorship. This seems to be a very common thing, and I think it needs to be clear that, well, first of all, it wasn't outright dismissed in Georgia with The Good Lie, with the Sudanese refugees, and the judge specifically said that somebody sharing their life story, even though it's not fixed in a tangible medium, there is a semblance of creativity involved. And so then the question has to be, was there the intention of forming a joint work together? But still, you're seeing a number of these lawsuits come up. So it has to be made very clear who owns the copyright, who owns the work. We mentioned earlier rights of publicity. There are questions of defamation. Believe it or not, you can be sued for defamation even if you fictionalized a character, because there are cases, including somebody brought up Law and Order earlier. Law and Order was sued, and I believe the lawsuit's still going on because it wasn't fictionalized enough. It involved an attorney, and it involved an bald Indian attorney who believed that this particular episode was about him, and they're very often loosely based. So the thing is that when you're considering whether to get a life story rights agreement, first of all, the question has to be, do you need one? Sometimes you don't need one. But there are advantages, and sometimes with a life story rights agreement, if the subject of your story signs a life story rights agreement, and part of the agreement involves them getting other people to sign agreements. Now, you can't bind somebody else with your own agreement, but you can say in order for you to get paid, you need to get XYZ people also signing releases.
So the basic question, what was your basic question?
Well, I guess after hearing that, should I ask permission to get a contract form from the characters involved?
Is what you're doing a true depiction of what happened, or are you going to fictionalize it?
Fictionalized.
Yes. If you're going to fictionalize it, you need to get their permission.
What about true?
Probably not.
But that being said, again, you still want to be careful about being practical about whether the likelihood is of getting sued. One of the issues is if you're trying to get errors and omissions insurance later down the line, and you've tried to get somebody's life story rights and they said no, that goes into the questionnaire, and so that might impinge on your ability to adequately insure with an E&O policy. That being said, the first answer, I'm sure Mark agrees, is speak to an attorney.
It depends. The short answer is it depends. If you're going to be perfectly truthful, and you can really be absolutely 100% truthful, you probably don't need rights, but I'm not going to say you don't. When we did Conviction, there were people who appeared in that movie, or characters who appeared in the movie, based on true life events, for whom we did not get releases. Okay, and we did it, and we weren't sued. So the answer is it depends. There were people from whom we did get releases. Barry Schreck, who was later on the OJ trial, and we got releases from Betty Ann Waters, whose life story it was, and things like that. But there were other characters for whom we did not get it, and that was a dramatization of a true life story.
And knowing who your potential adversary is important. If you consider the movie, HBO movie Going Clear, this was about the Church of Scientology. HBO very publicly declared they had 160 lawyers working on this. It wasn't an accident that was leaked to the Hollywood Reporter, because they know that the Church of Scientology sues over virtually anything. And they needed to, and in fact, Going Clear was not released in the UK because of fears of litigation. So if you have a good sense of who you're dealing with, truth absolutely may be a good enough defense against a potential lawsuit.
Which I think leads to the point that a lot of young filmmakers think that nobody can come after you. When you make these errors, the corporate veil can be pierced and they can go after you independently. So it's always good to start out and make sure that you have an attorney who understands the entire project, the best investment you can make is to have a good attorney who knows entertainment law, knows music, so that you don't end up seeing a lawsuit thinking that your corporation has protected you and you get individually sued.
Are you an attorney?
No.
Sound like a good one. But I want to actually disagree with you there on a couple of things. First of all, copyright, a corporation or an LLC will not protect you for copyright infringement. Like I talked about before, it's strict liability. Anybody who has the ability to control the disposition of a copyright is liable, whether or not they work for a company. Goes right through. I sued Michael Robertson, and on behalf of Garth Brooks, we sued MP3.com and Michael Robertson, the owner of MP3.com, for infringing on his copyrights when he ran MP3.com. And I sat in the judge's chambers and he said, I know you have a right to sue Robertson, but I'm not interested in having this case be decided among the individuals. You have to dismiss against Robertson. So I did, because otherwise the judge would be pissed at me for the whole case. But that was personal liability through the corporate veil on copyright. But on other matters where there's not strict liability, I believe that the corporation or the LLC or the S corporation or the C corporation, whatever it is, will protect you from liability. That's what it's there for. So I think that your statement was a little overbroad.
Not tort, though, right?
Depends on the tort.
Well, I mean,
Strict liability.
during
Too technical.
production.
Too technical.
Okay.
So you mean, in other words, if you running a corporate LLC, whatever, you make a movie, and there is copyright infringement, you personally can be sued?
Yes, sir.
It almost seems contrary to the whole idea of,
Yes, sir.
but that's safe.
The law is our
I've
ass.
been around long enough to know that.
The law is our ass. There's no question.
Are the filmmakers here still using errors and omissions insurance, or are you foregoing it? I mean, I'm genuinely
Well,
curious.
here's, the answer to that is they're using errors and omissions insurance when they get a distribution deal. But until then, they don't. Because you can't get a distribution deal without errors and omissions insurance. Because the distributor is not going to rely on your promise that you got everything cleared. They're going to rely on your promise that you made to the insurance company, because then if the distributor gets sued, he can look to the insurance company with the problem. That's the answer. But you need errors and omissions insurance. It means you need to think about that before you start shooting. It means everything has to be cleared.
Everything has to be what?
Cleared
Who
through
provides
a
insurance for films?
I beg your pardon?
Errors and omissions insurance, where do we start to shop for that?
With an insurance broker.
I'm only insurance for films. I'm trying to. Right.
So you call up your broker. You have a card?
Yeah.
Call her up.
Oh, okay.
Just say, I need insurance for my film. If she doesn't do it, she'll send you to somebody who does. And that's a relationship that you already have.
I have another question.
Yes, sir.
So, does the person personally sued, do they have to be the one that actually did it, or can they just be an officer of the corporation or the LLC? I mean, you can make a ghost person. Okay, she's a ghost. Now what? So they win, and now what do they get?
I don't understand your question.
Well, in other words, you say that somebody can be personally liable.
If they did something.
So they have to be, it has to be proven that an individual did it.
Well, someone has to, corporations don't act except with individuals. Right? The corporation doesn't move. If we own a company, and I'm the president, and he's the chairman, okay? And I'm the one responsible for making it happen, and the company gets sued, and they discover that he's the one who actually decided to make the infringement, they're gonna name him as defendant. They're gonna look for his deep pocket.
So they have to prove somebody actually did it.
Yeah, just like in any other lawsuit.
But like I said before, there are really very few consequences to casting a wide net.
Yes, sir.
So, I have an LLC. I do work for hire for other corporations. A lot of times, annual meetings, events, things like that involves video. If I use copyrighted material, known copyrighted material, say from a feature film, and incorporate it into that presentation, and on my invoices, I have a clause that says, we understand that this is copyrighted material, that the rights have not been cleared by my LLC, and we accept full and total responsibility for any actions thereof. And payment of this invoice indicates our acceptance of this. Is that enough, or do I really need them to sign a contract?
I'm confused.
I'm not sure I understand.
So you were creating industrial videos?
Right.
Okay, and you took footage from Star Trek and stuck it in your video. And your invoice says to the buyer, you've cleared nothing,
Right.
and they're
And they
responsible.
accept- Right, responsible.
The answer is you're liable too.
Still.
Why are you doing this? No, I mean,
If they pay good.
You should look into getting errors and omissions insurance is the answer to the question.
Okay.
And that way, if you forget to clear, wink, wink, forget to clear,
Right.
then you'll be covered.
Cut.
I'd like to make travel videos, so if I were like walking around Philadelphia and talking and pointing out things, at what point would I have to like blur people behind me, or if I'm out in public, would I have to, because there's always people walking in front of shots. At what point would I have to get people's permission, or would I have to blur their faces?
I hate this question.
I will tell you, I was out in San Francisco when I was trying to do this, and someone was walking past me like, you can't use this, and blah, 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 blah. So I never used it, but I didn't know if he was right or not.
I'm in the movie, oh geez, I forgot the name of it. Anyway, Crossing the Street, okay? So, I represented the Image Bank for a long time. The Image Bank was a stock photography house, and we got this question every single day. So I created a matrix of when it was appropriate, when it wasn't. If you're gonna follow somebody and they're gonna be part of your video, you can't do it. If it's really, if it's sort of in the nature of a news show, like you're talking about, and it's background people, it's hard for them to say no. If you put a sign up that says, I'm now filming a video, a travel video, and if you walk in here, you consent to being used, that's better. I don't know. It really depends. It's the hardest question to answer.
And it's also, again, state by state, but in New York, I mean, there have been some really interesting, astonishing decisions. There's the Neighbors case from last year where this photographer with a super telephoto lens was taking pictures of his neighbors across the building from him. And you know, sometimes they were in the nudes, little kids, and he made a gallery show of it. And I think it was the Northern District, one of the judge said, I would love to see something happen about this, because this is really creepy. But the fact is, there's no statute in the books that says he can't do this. So in fact, there were no consequences to this particular photographer now, because they found that it wasn't commercial use. So, I mean, I found the decision pretty shocking, but in terms of the interpretation of commercial use, according to the civil rights laws in New York, commercial use is much more for use in advertisement or direct commerce, like sales of products. There is a case in New York also where a mother and a daughter were bathing in a lake, and a guy was taking a picture of them naked, and it was used in an advertisement, and they were successful. The husband recognized his wife and daughter, and this was from behind. This wasn't fully nude. It was for like a cellulite product. Yeah, but it was like Au Naturel was the name of it. And
it's a great area.
And no, but the husband recognized his wife and daughter and sued and won. So the fact is that how it's used in New York makes a big difference. But that being said, I wouldn't take those chances necessarily. And this is where it's on a case-by-case basis again.
There's a case in New York also where a guy was on the front page of the New York Times Magazine without permission, and he sued and lost. Go figure. I think we have to stop. We're supposed to stop at 3?
3, yeah.
Okay, so we're stopping. Thank you. I see the next show coming up.